Oh, we have a comedy of errors today. Let's start that again. Welcome. My name is Jerome Rothman, and
I'm Aaron Franklin.
okay, and this is our Tozen Daigaku on fighting on unfair labor practices and labor commission. And the headline is Understanding Your Trade Union Rights. I want to begin by apologizing to those Tozen members that received this. We put out an email about an hour ago saying that the start time was 1:30. Clearly, we had been advertising it for 1 o'clock. So we decided to stick with the original time and start. So when we get a half hour in, I may apologize to those who end up joining us late as a result, and encouraging them when it's over to go back to the beginning. So apologies about that, and apologies for starting the Tozen Daigaku with us on mute. So with that out of the way, Oren, how are you?
Busy.
Busy? Yeah, we're all busy. So, I'm busy, but in pretty good place. So, the basic reason why we thought this would be a good idea is that as a union that is growing and establishing new unions at workplaces, without a long history of labor relations with management, sometimes management can be unfamiliar with the rights that workers have, and they either make mistakes or they do things that violate our rights. And so I think it's important that people considering joining a union, or people who are already in Tozen who are considering with their chapters whether or not to declare and ask for collective bargaining, make demands, that they know what their rights are, what the possibilities are if their rights are violated, and get an understanding of the legal processes involved in redressing violations of your rights. But first, in order to do that, we need to go over what your trade union rights are. So let's get started. Can you put up the slides, please?
Yes.
Okay. And is there a way to move the laptop in such a way that I can kind of like look over without looking too far away from the camera? Maybe not, I'm not sure. Well, actually, no, I'm not on the camera.
Well, you're still up.
So, okay, so so this is the Tozen Daigaku. This is the title slide for everyone that wants to know. Then we can move on to the next one. Okay, so in Article 28 of the Japanese Constitution, there are 3 rights listed that are considered the Rodo Sanken, or the 3 trade union rights, and they are Danketsuken, or the right to solidarity, Dantai Koshoken, or the right to collective bargaining, and Dantai Kodoken, which is the right to collective action, or maybe a more direct way to put it is the right to strike. So what do I mean when I say the right to solidarity? I was taught that historically the right to solidarity actually referred to the right to pay union dues. So if you'll believe it, in the past, workers collecting a pot of money, and doing great today. A collective pot of money that we would use as a collective resource to improve our working conditions, to run the administration of a union. That used to be a right that workers didn't have. So the right to solidarity historically traces back to that. Other ways to think of your right to solidarity are the right to discuss your working conditions with your coworkers, the right to join a union, the right to engage collectively in general with your colleagues. And so sometimes you'll even find that the other 2 trade union rights are considered sort of a subset of the right to solidarity. So that's Danketsuken. The second one is the right to collective bargaining. If workers form a union and union requests to management to meet for negotiations, management must meet the union to discuss their demands. Of course, those demands have to be related to your working conditions. If management refuses to do collective bargaining, that's a violation of your constitutional trade union rights. And then finally, there's Dantai Kodoken, and that is the right to, essentially, the right to go on strike, the right to protest. There are other forms of collective action that are protected by Dantai Kodoken. And one thing I'll point out is that none of these rights, like all rights, none of them are totally absolute. You can't just strike whenever you want. You know, there are different qualifications, different procedures that the law prescribes to direct the way that we assert these rights. But these are the three basic labor rights. So let's move on to the next slide. Okay, so let's move on to unfair labor practices. So the law that whenever you have a constitutional right, there are often laws and case law that define how to exercise that right, what protections are available if that right is violated. And that law is called the Rodo Kumiaiho, or trade union law. And so the article of trade union law that defines that directly interfaces with your trade union rights is Article 7. Article 7 of trade union law identifies 4 violations of your trade union rights that are called unfair labor practices. Now, before we move on, if we can move back away from the slides for a second, I want to talk about the expression unfair labor practices. Okay, unfair labor practices is probably the worst constructed legal term in the history of legal terms, although I'm sure there are a lot of candidates for that. So if you hear the expression unfair labor practice, you're probably thinking of a million different things, like that time your boss said something unreasonable to you, or that time, or maybe even just looking at your paycheck and how much it is might feel like an unfair labor practice. So sometimes it creates confusion that unfair labor practice, or even in Japanese, futorodō koi, these expressions evoke something different than what the legal reality is. There are laws that cover wages and cover treatment at work, safety, things like that, things that are fair and unfair at the workplace. But today, that's not what we're talking about. For all intents and purposes, an unfair labor practice is when management does something that violates the constitutional trade union rights of the people in the union, or the union as a collective. And so now I guess we're back on the slide, is that right? Can we put it back on? Okay. So now we're going to define what they are. So the first one, and I'm going to go through them, and then after that, we're going to go move on to define like sort of specific examples of the unfair labor practices. But the first one is furiaki toriatsukai, and that's in Article 7, Article 7, Part 1, number 1. And furiaki toriatsukai means discrimination or disadvantageous treatment. So if union members are being treated less well than non-union members, that is a violation of that is the unfair labor practice called in Japanese furiaki toriatsukai, or discrimination, disadvantageous treatment. Okay, and I'll give specific examples in a minute. The second one is danko kyohi. So if you remember, and danko kyohi in English is refusal to do collective bargaining. Now, if you remember, one of the trade union rights was your right to collective bargaining. And so if the union asks for collective bargaining and management says no, that's clearly a violation of your trade union rights and is therefore this unfair labor practice. But danko kyohi doesn't just extend to this outright refusal to collective bargaining. There's a kind of refusal for collective bargaining called fuseijitsu danko, or how do you say that in English? Bad faith negotiations. So the terms of that we'll get into specifics, but essentially, if it is established that management has refused collective bargaining or kind of made a sham of collective bargaining in a certain way, then that might, then that would be the second unfair labor practice of refusal to do collective bargaining, danko kyohi. So the third one is shihai kainyu, or interference with or dominance over union activity. So I'll give examples of this, but management is not allowed to interfere with the basic running of a union and the activities that unions do that the activities that unions do as part of their legitimate union activity. So if they do that, then they've committed interference with union activity. Another thing that management can do to interfere with union activity is to like dominate the union. So in English, there's this expression company union, which is the idea of a union that's essentially an extension of management, where like management might pick the executives or something, or the path to promotion would be through the union. That's not allowed. The union is supposed to be independent from management, and so if management tries to assert its authority in the union, infiltrate the union and make it its own, right? That could be another example of interference with union activity. And like I said, we'll get more specific soon. The last one, I always find a little bit confusing because it's oh geez, I just totally forgot the reading on that the kanji for this. That's how often we use it, but it's retaliation for using the Labor Commission process. I think that's Hofuteki or Hofukuteki. I'm not sure. When we get our other organizer back, I'll check, or if you could look it up. But anyway, but the idea is it's retaliation for using the Labor Commission process. And again, using the Labor Commission process is a legitimate union activity. So to me, it's almost the same as the number one, discrimination or disadvantageous treatment due to union activity. But yeah, if you decide to use the Labor Commission process, which is the process, like it's like the labor court that would hear your case if there was an unfair labor practice, then that would also, if you were retaliated against for doing that, then that would also be an unfair labor practice. So yes. Hofukuteki, I was right. Okay, got it. I was right. Hofukuteki Fudeki Toriatsukai. Sorry about that, everyone. Okay, so can we move on to the next to discussing discrimination and disadvantageous treatment against union members? Okay. So I wanted to give, I'm going to take a sip of my coffee here. I wanted to give examples of discrimination against union members. And I picked very obvious examples because I don't want to give management ideas on how to do Fudeki Toriatsukai. But I do think there are some really obvious examples that that would clearly make sense, and we've experienced, I'm afraid, from time to time. So for example, denying a raise to a worker due to union membership. So let's say they issued raises and they said, all the non-members are gonna get a raise, but all the members are not. That would be considered discrimination. That would be considered discrimination against union members. Okay. The next one is that I put on here was denying a promotion to a worker due to participation in union activity. So if there's evidence that a worker was discriminated against in the promotions process, gets lower evaluation scores because they're a union member, something like that, that could be considered a form of discrimination. And then, of course, one that a lot of people worry about, and it does happen, although it's not as common as you think, is denying a renewal to a worker who's a union member because they're a union member. So some of us are on fixed term contracts that are subject to yearly or every couple of year renewals. And if that renewal process, is used as a means of getting rid of a union member for the purpose of attacking the union, that would definitely be a kind of discrimination against union members. Now, one other thing to keep in mind is that the unfair labor practices have overlaps. You could also see some of this as interfering with union activity or discouraging union activity, which would apply to one of the other unfair labor practices. So sometimes one act that is aggressive towards the union could actually be covered by multiple unfair labor practices. So yeah. Warren, did you have a question or a comment?
I did actually. So with number one, denying a raise to a worker due to union membership.
Yeah.
If the union is trying to negotiate a raise and they're in the middle of negotiations.
Yeah.
And the company says, oh, we're going to give a raise to everybody, but then sort of say that, oh, well, the union member, could they put a pause on giving raises to union members because they're in the middle of negotiating for a raise that's like separate to non-unionized members.
I mean, so first of all, again, we have to be careful with the question, the can they question, right?
Sorry.
So, but it's instructive anyway. So just when you say can they can do all of these things. Is it possible? Can they questions always means, is it possible? Is it likely? And is it likely? Is it legal? And can we do anything about it? So is it likely? We've seen that happen a couple of times. So I can think of some examples where that took place. Is it legal? I don't believe so. I think that if management is going to unilaterally implement a raise outside of the context of collective bargaining, but then say we can't give it to the union because we're negotiating over a raise. If the union didn't want that, then no, I don't think management would get to make that decision. If the union and management agreed to put off the union members' raise during negotiations, that would be different. So I think a lot of it would have to do with how it's handled. But if you just imagine a situation where the union demands a raise, so they suspend raises to union members that would have happened anyway, simply because the union is negotiating over that raise, I actually think that would be an unfair labor practice. Yeah.
Then another question for number 2. What about then a company saying that they can't promote someone due to maybe like managerial positions because the person is a union member? So
that's another good question. And how can I put it? The more common version of that is they promote someone and then say they can't be in the union because they're management. So the thing to remember is that the union defines its scope of membership. So there are certain people that are high up enough in the chain that the union couldn't represent them, but that's pretty high up in the chain, right? And so the basic answer to your question is the union gets to determine the basic answer to my version of your question is the union gets to determine its membership, and union membership should not be a factor at all in your promotions, right? Like that shouldn't even be a factor. Now, there are times when management and the union agree to limit the scope. Agree is the key word as a product of negotiation, to limit the scope of negotiations to a certain level in the company. And so if that happens, then if someone gets promoted above that level, then they can no longer be represented by the union. That doesn't necessarily mean they can't be members of the union, but it does mean that they're no longer sort of part of what we would say in the American labor movement, that they would say in the American labor movement, part of the bargaining unit. Now, to answer your question, to tell someone I promote you, but you're a union member, absolutely not. If you had evidence for that, that would definitely constitute an unfair labor practice. Yeah.
So a person, it's possible for a person to be a union member and be promoted, but then they have a choice of either maybe potentially leaving the union or like staying in the union but not being represented by the union.
Yeah, I mean, I think the clearest way to see that question is that the union determines its scope of membership. So if the union is okay with someone being a member, then they can be a member. Yeah, it is possible that someone will be promoted to a level high enough where like they have independent hiring and firing power, and they have independent oversight of budgets, and they can make disciplinary decisions and all kinds of things like that make union membership itself confusing. And in that case, they probably can't, even on a practical level, forgetting a legal level, be represented. It's a pretty rare case. But yeah, and it's feasible that that person would then not be able to, we wouldn't be able to make demands on behalf of that person, but our organization can count whoever we want among our membership. So so long as it's within the union, how the chapter will in its constitution define its scope of membership, and it shouldn't exceed that, right? So anyway, is it okay if we move on from here?
Yeah, I was just going to say the third one is kind of a major one.
Yeah, it's a major one, right?
It's
yeah.
quite a difficult one maybe to fight or what?
Well,
Depends on-
everything depends on the evidence.
Mm.
Like we'll talk about that as we get into the Labor Commission process. But yeah, obviously that's, denying a renewal to a worker due to union membership or outright firing them, right? If you have evidence for that, then you can think of a more clear, more severe unfair labor practice. I do want to take the opportunity to point out that even though this seems like, oh my God, this is obvious, it must happen all the time, it really doesn't. Even some of the most frantic management, when they first hear about a union, they're going to call their lawyer, and if their lawyer is worth any of their salt, they're going to say, don't do that, right? So it's almost too obvious if they do something like that. But that's not to say it doesn't happen. We do have non-renewals and terminations that we believe are happened due to union membership. And in that case, we fight it. And we'll talk about what we can do to fight it as we move on. So, but yeah, that's a big one. But I don't want people to think that it's like super duper common. And the norms against that in the country are actually fairly strong. Yeah, let's move on to the next one. So the next one is refusal to conduct collective bargaining. So as I pointed out, like the most transparent case of refusal to conduct collective bargaining, I'll sort of walk you through it. So we form, let's say, a chapter of Tozen Union, Nantoka Eikawa Union, right? And you get together, you decide you're going to tell management that the union exists. That's a decision that you make. We call it declaration. And you've listed up the things you want to improve, like you want to raise, and you want to, you want to turn your fixed term contract into a permanent one, and a few other things. And we call those priorities that the union makes. They're called demands, or yokyu jiko, right? So, and then we submit that to management formally, and we request collective bargaining at such and such a time and date. And management ignores the message, sends a message back refusing to do collective bargaining and gives some sort of excuse, or in any other way just doesn't do collective bargaining. That is clearly danko kyohi. That's clearly the unfair labor practice of refusal to negotiate. I think in my 13 years of being a union organizer here in Japan, that has happened once, maybe twice, once. And I'm going to say once. And that's the most extreme example of this. And therefore, it would seem almost like if that was all that refusal to conduct collective bargaining meant, that would be way too thin a standard. So there are some other examples that through case law, through regulations that have become understood as part of refusals to do collective bargaining. So one is called fusei jitsudanko, right? Or bad faith negotiation. Now, the bad news about this is bad faith negotiation isn't when management is being unreasonable in collective bargaining. Like our understanding of what's reasonable and what's not, for the most part, doesn't impact whether or not management is committing bad faith negotiations. Some of you who've done collective bargaining could be forgiven for believing that every single negotiation you've been to, there have been evidence of bad faith. Some of you have better luck in collective bargaining. But there are some specific things that apply to bad faith negotiation. So for example, if management doesn't bring decision makers to the table, or if they just outright I don't say lie, but they just say things that are totally untrue in collective bargaining, they mislead you. Depending on the severity of it, right, that might be considered bad faith negotiation. Another example is if we make financial demands and management refuses it, but doesn't show us why they refused it. In other words, doesn't give us relevant financial information to justify refusing a raise. That could also be considered bad faith negotiation. And the final one is just refusing to answer questions so that are relevant. Outright refusal, like if management just doesn't answer your collective bargaining request or refuses to meet or stalls forever, those are easier if we have to go to Labor Commission to adjudicate the dispute, right? Those are kind of easier to win. The problem with Fusei Jitsudanko is a lot of it is in the eye of the beholder. So the union, of course, tends to want to hold management to a higher standard of good faith negotiation. And of course, management tends to want to hold itself to the bare minimum standard, right? That's just kind of the natural order of that. And you have to convince a third party that this bad faith behavior is so bad faith that it's actually violating your rights. And, you know, it can be quite subjective. It is, you know, not the easiest thing to pin down. So, you know, if management does something once that's kind of bad faithy in CB, that doesn't mean you immediately run to Labor Commission and file a petition, right? You want to establish patterns, and then once you know that you've got the case and you know it's advantageous to pursue it, then you would. But yeah, I always want to make sure people are aware that your standards for good faith negotiation may not be the same standards of the third party that looks at it. Another one that's happened quite a bit in Tozen's history is when management tries to unilaterally set rules for CB. So I gave some example cases, and I'm going to get into this in more detail, but language. So we have a lot of unions where the language of labor relations at the workplace isn't Japanese. All of the correspondence is in English, all of the work orders are in English, all of the contract negotiation, at least between the individual members and management, are in English. And yet management, when it comes time for collective bargaining, says everything must be in Japanese. And so that does have the impact of creating a higher standard, a higher level of burden to members who want to negotiate collectively versus wanting to deal with the company individually. And so we've been able to we've been able to win a case with the Gakugeidai case where, you know, in a situation like that, management can't unilaterally set rules for collective bargaining. The rules for collective bargaining also have to be sort of adjusted or you know, based on a good faith exchange or even negotiation between the two parties. So that's you know, the union and management. So that's one. The next one is participation limits. And this was, we adjudicated this in the Oberlin Daigaku case, where we had many members at that local, and management wanted to limit the number of people who come to collective bargaining to a certain number. And that was a very small percentage of the union membership. Tozen union is a strategy, brings as many people to collective bargaining as we can. Now, if management and the union agree to set a participation limit, then it's not an unfair labor practice. But if it's unilaterally imposed and management creates a lot of evidence that it wasn't negotiating that in good faith, it was just saying, we won't meet you if you bring this many people above our limit, then that could be an unfair labor practice. And we actually won that case as Oberlin Daigaku. Location. So, you know, sometimes headquarters is in Ibaraki, and sometimes the workers are working in Shinjuku. And if management says, oh, you can do collective bargaining, but you all have to go up to Ibaraki, you know, because that's where head office is. If they unilaterally impose that condition and refuse to meet for collective bargaining unless you agree to it, then that could be an unfair labor practice. And then, Lewis added one to this one, all of the above plus refusal based on type of demand. He's off camera now, but the Lisey case one that you added, do you want to maybe jump in and say something about it? Yeah, Lewis is going to speak off camera about that, but he might know a little more about this.
No. Yeah, so it's basically in the Lisey case, we are suing the Labor Commission over this. They're refusing based on the type of demand. And when I say type of demand, they claim that, first of all, some of the demands they've already answered, meaning years in advance, years before the CB. And other demands they claim are not in the domain of what should be negotiated with a union. And they have a different commission where they listen to the voices of the workers. It's called a Human Resources Council, where they listen to workers' opinions on different issues. And because it's an agenda item on that committee, therefore they claim they don't have to discuss that demand with the union. Of course, we think that's an illegal refusal, and that's part of our suit in the Labor Commission.
Okay, thank you very much, Louis. Sorry to surprise you with that, but I figured since you're here. So and then I wrote lastly, and I've already referred to this a little bit, certain forms of non-response or zero kaito, like, if you ask questions related to your demands, like why are you refusing this demand? And they say, because they just don't answer the question. Depending on that, you could say that the refusal to give a reason or that the reason they gave, like sometimes we'll get one of these where people will say, management will say, the reason why we are not agreeing to that demand is because you already signed a contract in the past that stipulated this condition. So I'll be more specific. Let's say you ask for a raise and management says, we're not giving you a raise because you agreed when you signed the original contract to this wage. That's actually not an answer, right? The whole premise of collective bargaining is that you're changing the working conditions that were agreed upon when you had no choice. It was take it or leave it because you just got a contract and had to sign it. That's the whole premise. And if they say something in collective bargaining or establish a pattern in collective bargaining, that the reason they're not giving into demands is because you already have a contract, like that is refusal to negotiate. So that's an example of certain forms of non-response that could be an unfair labor practice. By the way, you do notice that I say a lot that could be an unfair labor practice. And I do that because a lot of these things are circumstance dependent. And the biggest circumstance, we're going to talk about this when we get to the Labor Commission process, is the person or people who are in Labor Commission adjudicating your case, if you end up taking a case there. A lot of these things, unfortunately, are subjective. And so, I think personally that all of this stuff can be really clear unfair labor practices, but I'm not a judge on Labor Commission. So, you have to convince the third party that this rises to a certain level. So that's why so I don't want to get too far ahead of myself, but that's why I use tentative language. So if you're replaying a collective bargaining in your head and thinking, yeah, management did that once, they said we didn't have a decision maker at the table, we should sue over that. Well, it's almost always a lot more complicated than that in terms, not complicated, but it's a little more, you always need to establish patterns, right? And develop a body of evidence that shows that this is amounting to refusal to negotiate. So I'll pause there if you had some questions there, Oren.
Yeah, so one of I've got a few questions. So bad faith negotiations is quite in a way, broad term. What's the difference between maybe a bad faith negotiations and sort of the zero sort of non-responses?
Well, non-responses would be a form of bad faith negotiation.
That's what I was
thinking.
So,
So what I should say is outright refusal is one, and then number two is bad faith negotiation, and everything like 3 and 4 are just forms of bad faith negotiation. So maybe my outline's a little confusing in that regard, but yeah, all of this is, if we're having a negotiation and you say I'd like X, and I say no, and you say Y, and I say I don't have to give you a reason, you can't possibly call that a good faith negotiation, right? And so if it's clear that that's happening over and over and over again in collective bargaining, then you might have a pretty good case that a third party would agree with.
Okay. With 3B, the participants limit.
Yeah.
So this is something that's over the past, let's say, 3 years specifically, that has, I think, been something that's been a factor in a lot of collective bargainings with Corona. Like a lot of places or within Tolerate itself, within like collective bargaining, there has been a set on participation or participant limits. So how has there been much of a push for change lately, or has there been anything?
Well, so what surprised me, I think what you're talking about with COVID, right?
Yeah, I didn't think I was being too.
Yeah. I'm being too quiet, being a little quiet about it. But with COVID did some interesting things to collective bargaining. One thing it did is it moved a lot of collective bargaining online. And there are good things about that and bad things about that. Remember that the one thing that is it's the trump card. I don't know if it's the right word, but the one thing you have to remember is the key is their agreement. So if management wants to do collective bargaining online and the union wants to do collective bargaining online and then collective bargaining is online, then there are no problems. If management and the union want different things, then they have to negotiate those rules in good faith. What surprised me around COVID was how much cooperation we did in fact get from most management, not all, on these kinds of preferences. So you would expect that management would use safety as a reason during the pandemic not to have collective bargaining. And that did happen. And we did have a couple of labor commission cases about that, that were settled to the mutual satisfaction of the union and management. So this did come up, but for the most part, I would say, at least in my portfolio of cases here at Tozen, right, like we were able to work that out. This isn't about unfair labor practices. This is about the mechanics of collective bargaining. But in my cases, it did kind of create other norms around collective bargaining. So if you're online, you're going to have more people in the session. So you need to come to accommodations on how speaking is going to work. Everyone can't talk at once. And so almost naturally, each side ended up taking its designating certain people having different roles in the collective bargaining a little more seriously. So collective bargaining, if it breaks down or if things happen in the session that are a bit like contentious, sometimes there can be a lot of crosstalk, but that was sort of mitigated in a way by having it online, is we all had to be a little more disciplined to make the most use of the session. So the answer is that it did cause some problems. The surprising part to me was that in very few cases did management simply refuse to do negotiation based on the pandemic being there. They were at least willing to find an online method. A final point is that if management is able to cite a legitimate safety reason why we can't have more than 5 people in the room, right? Like that will undermine your case that it's unilateral. So you wouldn't, like it would have been outside the norms in, I don't know, April 2020 for us to insist that they accommodate 20 people in the same room as, however many management wants to bring. So, this is why I always say a lot of these things are very situation dependent, but the easiest way to think about stuff like participation limits or rules for CB is if management's attitude and posture and actions are unilateral, we love that word in Tozen, ipoteki, right? If it's really clear that there's the directives on how collective bargaining will work are coming from one direction, that's where you're running into unfair labor practices. So to answer your question, did it come up? Yes, not quite in the way I was expecting though when this all started.
But well, more my question was like, how are things now? Have there been any changes?
Yeah. So at risk of getting too far off the discussion of unfair labor practices, some collective bargainings have gone back to in-person. Some collective bargainings, we just found that it worked better and we've stuck with it. I think that it's depended very much on the local, on the chapter, right? We call our chapters locals in Tozen.
Yep.
Can we move on?
Yep.
Okay. So the last one is interference with domination over union activity. So here's one that sometimes people, particularly Americans, might find kind of surprising. Speech and actions that discourage union activity. So, I read today that like Elon Musk said something on Twitter, like, why would you ever want to join a union and pay union dues, something like that. Even, I don't know about the laws in the United States, but in Japan, if you have that kind of statement from management, that's shihai kainyu, or interference with union activity, right? Management is not allowed to discourage or cast aspersions on union activity. So that's one thing that's one concrete example. We've had that happen, right? We've had management say things even in a collective bargaining session that would say, you know, union activity is bad or compare it to something heinous like a punch in the face or something. That actually happened recently in one of my sessions. That's Shikai Kainu management's not allowed to do it. And if you establish a pattern of that, then you might be able to convince a third party that it is interference with union activity. So the next one is interference with leafletting. So let me sort of explain. You don't have an absolute right to distribute materials at the workplace. So if you're in the break room and you want to hand your coworker, you know, a union leaflet, and management says we don't want to, you know, be passing these kinds of things in the, you know, in the break room, you know, depending on the circumstances, management will have some right to like restrict your activities on the premises. But the union does have the right to recruit union members by standing, you know, on the public sidewalk in front of the workplace and distributing leaflets, right? Another thing that could happen is if you've entered into dispute, like you've gone on strike, during that strike, there might be a protest in front of I was almost naturally saying in front of the school, in front of the workplace. And in that case, you might be handing out leaflets, making speeches, you might even have the megaphone there. If management comes in and tries to interfere with it physically with their bodies or to chastise you for doing it, that's Shihai Kainu, that's an unfair labor practice in trade union law.
Calling the police.
So calling the police is interesting. I think calling the police is an unfair labor practice, and I believe you can make that case. It's kind of hard because the police don't always tell you if they were called. Like, it's hard to prove, right? Police can just come by. By the way, just so everyone knows, if the police do come by, you have a right to do these things. So we have a right to do recruitment leafleting. We have a right to protest during a labor dispute. And what we've had police come by and sort of check out the situation. The police have, I don't think in my cases, they've ever interfered with the leafleting itself. I think if they call the police, it's an unfair labor practice. I did hear a legal theory that you always have the right to call the police. So it's going to be up to a third party to adjudicate that. And again, you know, like I say, sometimes these things are squishy. But my opinion is that if they're calling the police for something they know is legitimate union activity, that's definitely interference with union activity. It's just like kind of tough because you have a right to call the police. So it may not be the easiest one to prove. Can I do 3 and 4 and then?
Yeah.
No, it's fine. Yeah. So I talked about dominating the union, management controlled unions. I don't have a lot of experience with this one because Tozen is a fiercely independent, democratic, transparent union. And we just don't have, I don't actually know any concrete examples of it. But the other thing that I would also say is that there are actually a few unions in companies that appear to me to be sort of inculcated into the management structure. I don't want to accuse anyone of anything, but unfortunately, this practice might be more common than it would appear to Tozen members, where whatever problems we might have with our union, one of them is not that management is dominating the union and like running the elections. You know what I mean? So, I don't know much about that, but management, if management tried to exert political control of the union, there was evidence for that. That would be an unfair labor practice. And then, another one, again, this overlaps with the disadvantageous treatment, but disciplining members for legitimate union activity. And this is one of those kind of more subtle ways that management can do an unfair labor practice and maybe try to make it look like it's about something else. So for example, like if a member has a conversation with a coworker during a break in a way that doesn't interfere with work at all, saying, hey, we're having a union meeting tomorrow night, you want to come? And management overhears it and says, you're not allowed to talk about that at work. right? That would be a violation of your right to solidarity, right? You have a right to talk to your coworkers about union activity. Of course, if you're doing so in a way that interferes with work, then management might be able to discipline you for that. But I should say it might be legal for management to discipline you for that. But if what you're doing is innocuous to the work getting done, and it's specifically targeting union conversation, but perhaps if you were talking about your concert over the weekend, nobody would have cared. Like that would definitely be, you know, a form of interference with union activity, Shihai Kainyu. And I think if you can make a compelling case to a third party that would adjudicate it, that's an unfair labor practice in trade union law. So I do, yeah, I think I'll leave it there. Did you have any questions?
Just kind of with like number 4.
Yeah.
So, for example, disciplining members for legitimate union activity. So, for example, things said in collective bargaining can't things said or actions taken, depending within reason in collective bargaining can't then be used as reasons for like discipline or disciplinary action later down the line by the company?
That's a good question. So the answer is that legally in collective bargaining, the union's status and management status are supposed to be made equal. So management, so if it's, you know, if management has, let's say, a standard that we want people to be cooperative, and you in collective bargaining demonstrated an uncooperative attitude, right? That would definitely be a lot of things. that would be interference with union activity. But the thing is that equal status doesn't give you carte blanche. Like, no matter what, if you have equal status with someone else, don't commit an act of violence in collective bargaining. Not that that's ever happened in Tozen's history, but you know, that's not even a question of discipline at that point. That's a question of committing a crime, right? So you know, like it's not a you don't have like immunity because you're in collective bargaining, but you do have immunity from like being punished for violating a work rule by saying something in collective bargaining that management didn't like. So you know, but you know, the idea is, I think the kinds of things you're thinking of where maybe you got mad and you yelled in collective bargaining, and yelling does happen in collective bargaining. They can't say, well, we're giving you this warning letter because you shouldn't yell at managers. That would definitely, and I say definitely to me, right, clearly indicate interference with union activity. And I think you might also be able to call that bad faith negotiation. I'm not really sure, but yeah.
Or like complaining about your job within labor bargaining.
I mean, collective bargaining, I mean, to a certain extent, collective bargaining is complaining about your job. I mean, hopefully it's constructive, but you know, I mean, that's the point of collective bargaining is you have complaints that you're making and you want them resolved, right? So I should say the legal point of collective bargaining is to, for both sides to achieve settlement on the demands in the form of a labor management agreement. So long as you're doing that in collective bargaining, management really shouldn't, you know, take action against you in the workplace for what you did in collective bargaining. Is there anything else we want to do here?
Not that
okay. So when we did the labor consultations, Tozen Daigaku, I talked about how one of the tricky questions we often get is, can management, whatever, can management fire me for being in the union? Can management, you know, lower my pay for being in the union? Can management harass me or something like that? And the problem, of course, with can they questions is the answer is always yes. Can management do everything I just described? Yes, of course, it is possible, and management breaks the law all the time. Sometimes, you know, some of these are more likely, some of them are less likely. And that's why I always tell people that when you ask a can they question in a labor consultation, or even if you're just thinking about your union strategy, the more useful way to approach a can they question, can management do this, is to break it down to 3 questions. Is it legal? Is it likely? And can we do something about it? So the things that I identified are illegal, right? They're unfair labor practices. That is to say, violations of your rights in trade union law and your constitutional rights. And is it likely? Some of these are more likely than others. That is to say, depending on the situation and depending on the company, depending on and just in general, we see higher incidences of some of these than others. So like the outright like non-renewal or firing or, you know, saying we're not going to do collective bargaining, and, you know, it happens, but it's rare. Some more subtle things that I talked about, things like the examples of bad faith negotiation, those are more likely that we see more incidences of that, right? And so that's what we tend to be more on the lookout for. So then that last question is, what can we do about it? And what I think makes unfair labor practices special among the many different laws that protect your rights is that there's actually a process that seems to work pretty well if these unfair labor practices get to a point that you need to involve a third party. It isn't always the case with other laws. So some laws, for example, like a violation of labor contract law, you have to sue in a court in order to resolve that. And depending on what that violation is, the sympathy of the judicial system is almost always on management side, and you have to deconstruct a great deal of pro-management bias to get satisfaction. And that doesn't make it impossible, but it does mean that those processes are harder for the union. Those legal processes are harder for the union to use than the one I'm about to describe. Another example is the Labor Standards Office. So depending on what violation of labor standards law you're pursuing, they are more or less willing to help you, even if it's clear that management broke the law here. And, you know, I'm not trying to malign, there are some very good labor standards inspectors, and we've had some luck with Labor Standards Office, but I do find that process to be a lot harder to get the government on your side than the process I'm about to describe, which is Labor Commission. So can we move on to the slide, Labor Commission? Okay, so Labor Commission, probably you've heard of, if you're again, I apologize, I'm an American, so I have that frame of reference, and so some of you might have the frame of reference of the National Labor Relations Board, and that's basically the model that is used here, except here it works, and it's and the Labor Commission, or Roto Inkai, is part of the labor ministry. And the way it's organized is it's organized by prefecture. So every prefecture has its own labor commission. And Tokyo has Tokyo Labor Commission. I've only done labor commission cases at Tokyo Labor Commission, but there's a Kanagawa Labor Commission, there's an Okinawa Labor Commission. It's a labor commission in every prefecture. One unique feature about Labor Commission that's actually different from court is that the union can sue in any labor commission around the country. So if you imagine a situation where the unfair labor practice happened in Okinawa, but it's a national union with its center in Tokyo, then even if the unfair labor practice happened in Okinawa, we can sue in Tokyo Labor Commission, right? That can be quite useful. Management doesn't have the right to insist that it be done elsewhere. We've had that happen where during the Hart case, they wanted us to move the location for this case, and Labor Commission told them no, because we actually get to choose. The first step, first of all, before you even get to Labor Commission, if an unfair labor practice happens, the most important thing is that the union and management, I should say the union, try to resolve whatever that problem was before you file a petition. So like everyone, like it's very easy to hear something in collective bargaining or see something happen that management wasn't supposed to do. And then the instinct might be run to Labor Commission with a petition right away. That's almost a surefire way to lose a labor commission case, because whatever the violation is, labor commission tends to want to know that the union's trying really hard to resolve things before it escalates to a point where they have to get involved. So before you even consider going to labor commission, and you would make those decisions with, as a union and with your case officer, and also, we would have democratic process to decide, okay, we're filing this petition. But before any of that happens, if management commits an unfair labor practice, you file a protest letter, you ask for a collective bargaining on the issue, you try to negotiate over it, you get management to continue to not, either you get management to resolve it, which is the goal, maybe not apologize, but say, okay, we won't do this again or something like that. Or you try to get an agreement that it won't happen again. You do what you can to resolve it through the power of your solidarity at the workplace. And then if that fails, if management is either not just repeating the unfair labor practice, but perhaps denying it or, doubling down on it in some way, at that point, you would then file, it's called a Todorokoi Kyusei Mushitate, the document Mushitate show, or petition to redress an unfair labor practice. And so this is usually a fairly simple document that explains the basic background about the union and the chapter of the union, if there's a chapter of the union involved, little information about management. This is written by the union, by the way. And then an outline of what articles of trade union law were violated and what the union is seeking as a remedy. And in most cases, the remedy is an acknowledgement that this action happened and an apology letter that's posted publicly at the workplace and possibly online. Sometimes if the unfair labor practice resulted in a loss of income or somebody losing their job, you could also ask for reinstatement and back pay. There are no like damages like suffering, what do you call it? Pain and suffering kind of damages that you can get in labor commission. And I think that a lot of us think that these apology letters that you would get at the end of it, that we call them post notice, a lot of people think, well, that's pretty weak. Why would we spend all this time and energy just to get that post notice? But management seems to fight them really hard because it's a pretty severe condemnation of what they did, and they have to file it, and they file it under their hunko with you, and you can put it on a sign and wave it around. It is actually quite a deterrent. Management doesn't seem to want to suffer that humiliation, and so that norm, powerful norm, can really motivate management to avoid unfair labor practices. They tend to fight unfair labor practices charges at labor commission quite vigorously. So that petition would include which remedies you're seeking, of the possible remedies, and then it would also give a basic outline of the background and what what the union's claims are. Right? After that, there's Chosa, or the investigation phase. And that's when management will write a formal response to your document. And then there's a lot of paper passing back and forth, right? So we'll write a brief, they'll respond to the brief. We'll submit evidence, they'll respond to the evidence. And this can go on for a long time. So unfair labor practices cases, it's not uncommon for them to last 2 years. And COVID actually turned some 1.5, 2 year cases into 3-4 year cases. I used to think that the length of time was a real burden, quite cumbersome, but I've grown to realize that the length of time does some good things. Evidence is important in a labor commission case. And at first, sometimes there's not a lot of evidence, but it's very tough for either side in a case to keep secrets for a very long time. Things tend to leak out. And so the length of time actually does kind of allow a bit of a discovery of evidence, right? It also tends to create pressure on both sides to think about ways to settle it. So you'll notice step 3 says wakai, or settlement. Now, this doesn't happen at one specific point in the labor commission process. Labor commission will always put pressure on both sides to settle. They want both sides to write up a document that will resolve the case and not go to verdict. That's what they tend to hope for. They don't like to write up verdicts if they can avoid it. And they're rather proud of their rate of settlements. And the disadvantage to this is that the union sometimes comes under intense pressure to accept settlements that it doesn't want. But the advantage to it is management also comes under that pressure. And so at any point during the CHOSA stage, if the Labor Commission gets even a hint that a settlement might be possible, then you'll sort of transition into almost like a mediated a mediation phase. And I've been in Labor Commission cases where we've kind of gone in and out of that a couple of times. If you actually settle a case, that would mean, for example, like maybe there's you've decided your CV rules that you wanted, and then in response you withdraw the petition, and then the case disappears and you just move on. Or yeah, there's other forms of settlement. I don't want to get into it too much here, but yeah, those are possibilities, and at different stages in the case, the commission will always pursue it. So just to imagine like a normal Labor Commission case, you filed the petition, you've had 2 or 3 hearings, then suddenly there's a hearing of settlement talks. They kind of don't work out, then you go into a few more hearings, and it's about 1.5 years later, and you get to the next phase, which is testimony. So it's not necessary to do testimony, but we try, if we get to this stage, to do it. Once everyone's pretty convinced that, okay, this case is going to verdict, each side can decide which witnesses they want. You do not get to call witnesses from the other side. For those of you who have done Labor Commission cases, you'll notice that that is the phase where interpretation might happen. So if you're an English speaker, they might they'll hire an interpreter, and Labor Commission interpreters tend to be pretty good. You write up your, you have to, the key with testimony is that you have a direct examination, and then management also can cross-examine you, and then with management witnesses, it's the same. So it's the most like a TV court type situation that organizers ever get to live in. So yep, that's testimony. Yeah.
What was the kanji for testimony?
So I think that one is, I always confuse if it's Shinmon, right? Yeah, Shinmon. So I know in court it's Jinmon, isn't it, Louis? Yeah, so I always get those confused, but Shinmon is the testimony for Labor Commission. We're behind, like he's yeah, you're behind this. Yeah, so there's a delay. Okay, so after testimony, if you believe it, they almost always throw in yet one more settlement hearing, just because they're always trying. And then what they do is they officially close the case, and you go to something called a meade, or I prefer to translate it as verdict, but it's actually order. And it takes 6 months after the case is closed to get this. And this will be the one that decides that if you won or lost the case. And sometimes there are multiple charges. So some the commission will agree with the union, and some the commission will not agree with the union. What happens, let's imagine a situation where where let's say somebody was, let's say like the Gakugeda case is a clear example. So we got all the way to the end, we got the verdict, and management ruled that the Labor Commission ruled that management had violated the union's rights by unilaterally insisting on CV rules, and ordered management just to negotiate with the union in good faith on this issue and apologize. They didn't say accept the union's proposal, but the impact of that order was that management sat down with us, they issued the apology, they sat down with us, and then we ended up finally negotiating a proper settlement to CV rules. So winning a Labor Commission verdict can, at that point, like kind of strengthen your hand. in the negotiation, which is one reason why maybe management resists it. That happens sometimes. What happens more often in my experience is that if you go all the way to verdict and the side that wins will appeal the case to the next level. The next level in this case is called Chuo or Central Labor Commission. Also, sometimes both sides do it because one side won one part and the other side won the other part, right? And so both sides end up going on to another process. And the Central Labor Commission case is basically the same as the original case, but the emphasis is on anything new, because the theory is that the commission, like the first commission, in this case, like Tokyo Labor Commission, made a mistake, and so we need to point out what that mistake was. So there's a little pressure on like keeping the testimony much more narrow, etc. And of course, at the Central Labor Commission, they're always seeking ways to settle. So if that doesn't work out, then your option is to sue the Labor Commission in court to overturn the verdict. And that can go all the way up to the Supreme Court, from Tokyo District Court to the appellate court to the Supreme Court. So that's a basic outline of the Labor Commission process. And the reason why I wanted to take the time to go over the Labor Commission process is because this is one of those processes that turns out to be very valuable. However, I also do want to point out that you don't want to go to Labor Commission. You want to be powerful enough at the workplace that unfair labor practices basically don't happen because management's afraid to do it. And you want to be powerful enough at the workplace that when management does commit an unfair labor practice, they find a way to resolve the issue before it litigates. So a lot of times people equate doing something in Labor Commission or court with seriousness, but I tend to equate doing something in court and Labor Commission with a symptom of the fact that we're not as strong at that workplace as we could be or should be or want to be, rather. It's not a judgment, sometimes organizing is tough, we know that. And we use Labor Commission a lot in Tozen, there's no shame in it, but of course you want to avoid Labor Commission if you can be powerful enough to negotiate a reasonable settlement with management. I'll pause here if, Warren, you have any questions, and then I've got a few final thoughts I could wrap up with before we hit questions from the audience.
Okay, so with the Merde from Labor Commission.
Yeah.
Oh, one thing I'm not sure if we also mentioned is that sometimes we shorten the name of Tokyo Labor Commission to things like Toroi.
Or Churoi. Yeah, I did that here with the Chuo Rodo Inkai becomes Churoi. Tokyo Labor Commission can become Toroi, maybe. Toroi. Sorry, pronunciation.
So, that got off topic. So sometimes after the verdict and the order, and if there's appeals, I'm not sure if you mentioned how long between the verdict and does either side have to make an appeal at Shuroi?
Yeah, that's a good question. So the first thing is just to point out that you have, so the first stage is your regional labor commission, your prefectural labor commission. So that's like, for example, Tokyo Labor Commission. You get the verdict, and from the day that the verdict is in your hands, right? So when they hand it to you or they post it to you, from the day that that happens, you have 30 days to appeal to Central Labor Commission. But you also have the option to bypass Central Labor Commission and go straight to court. There are some reasons why you might want to do that. It's a bit cumbersome to get into it because like usually we just go to Central Labor Commission. But if, for example, you wanted to have maybe a little more time to prepare, for example, you have 6 months to sue over it if you're the union. I think management in both cases, if they want to appeal, they have less time, they have 30 days. So that's the appeal deadlines, you know, so, but basically it'll say it on the verdict, how much time you have to appeal. So then you want to take note of that. So if you're appealing to Central Labor Commission, you have 30 days, I want to say 30 days, and 6 months if it's going to court. And I think management always has just 30 days. So I might be wrong about that, though. I might have to double check. I apologize, but yeah.
So
That's the case.
yeah, then a kind of follow-up with that would be if a sort of company side or management was to make an appeal, then what's like, do they then have to follow like the order? Like, so if they, or can they sort of try and postpone? Like if they, for example, they were told, oh, you've got to take this worker back.
Yeah.
And then they say, oh, well, we're currently appealing at like Central Labor Commission.
In my experience, they are not required to follow the order during the appeals process. Yeah. So, like one example, we did try to contest it once. We had after Central Labor Commission management appealed, and like the penalty was an apology letter, and so we were saying, well, this order stands. They should follow the apology letter, but they should file the apology letter. But it was explained to me that like if the whole thing they're trying to avoid is the public apology, and then they've already made it, then the appeal, it would render the appeal meaningless. So yeah, I wish it were like they'd have to, like, to me, the sensible thing would be that in a case of a dismissal, that they would have to take you back. I guess they would just refire you at the end of the appeals process. Like, I mean, that would, I mean, it is a bit weird. But yeah, unfortunately, like, yeah, a lot of these things are kind of biased towards management. So yeah, they're not toward the eyes of required to take you back in that case. So yeah, you have to win. But the thing is, at whatever stage it finally ends, so there's a stage of the verdict, the mayday, it's called kakte. That means like when it's become, you know, like concrete or like permanent or I don't know how it's kakte. It's weird. Set might be a good way to put it. And at that point, they have to follow it. And if they don't follow it, then there are penalties, and they're not easy. They're not easy. There are penalties there. It's not automatic. You'd have to file. The commission will actually pursue the penalties if the verdict isn't filed. And Labor Commission does tend to get mad because they are the government. So if after all of this management doesn't follow the verdict, they tend to get pretty upset about it, right? Because they did a lot of work for that. So yeah, management tends to follow the verdicts unless they're completely like criminal. It is actually, I think, a crime to not. I'm not sure if it's a crime. Anyway, whatever. I'm thinking out loud. Apologies. But yeah, it's once we get to a verdict that's set, then you know management tends to comply.
So I'm not sure if this is then going into what you said at the beginning.
Yeah, I don't want to teach management how to avoid accountability.
Yeah, so for example, can like the union like file a case of the appeals process being abused in a way as an unfair labor practice?
No. Finalized. Oh, that's good. Finalized. Cocktail. Yeah, thank you. So we keep our dictionary, our handy Lewis dictionary around, the universal translator. Okay, so I have a few final thoughts, and then I'll ask maybe if we have a participants' questions. But I already gave the example cases, so can we just move past this part? Yeah.
This JCFL one.
Yeah. So okay. So
both JCFL.
I think I gave, yeah. So Outright was a company called Pearson. They just refused to do collective bargaining, and they actually refused to turn up to Labor Commission. So we won that case pretty easily. I already talked about the language with the Gaku Geidai case and the Oberlin Daigaku case. Interference with union activity. We were doing a recruitment leafleting and management had sent out a staff member who's following management's orders to physically obstruct the leafleting. We have a great picture of one of the staff members under management's direction physically obstructing a leaflet. So that was a case for interference of union activity. The other ones I've already gone through, so I don't want to waste everyone's time again. But
What
yeah.
about the first one?
Oh, discrimination. Sorry, I forgot about that one too. Yes, so the discrimination case. So one of our members in JCFL was routinely assigned extra work for open campuses, and then shortly after the union declared, those extra assignments stopped, and you know, that extra work generated extra income because it was work outside the regular contract. Management made the claim that it was never guaranteed, but we made the claim that this was done to retaliate against our member for having been in the declaration. This case is actually still ongoing. We won at the Tokyo Labor Commission, at Central Labor Commission, and I think at the last two court hearings. Now we're on like a third level, the third court rung for this. So you know, I think we have a strong chance of winning in the end. But yeah, that's an example of discrimination. So like if you're getting extra, again, you need evidence that the reason is union activity. And I guess our third parties that the Labor Commission, the court so far have found that there's enough evidence to substantiate that claim. So they've sided with the union on that. You know, that's the open campus case. So yeah, so those are some examples. You'll notice I don't have an example for retaliation for using the Labor Commission process. And I think the reason for that is what I said before. One, to me, that's almost the same as for the Yakitori guy, the discrimination against you for using the union, for having general union activity. And we just don't have any really good cases that I can think of that. But it follows the same pattern. So we've moved on to my closing points. So I say, even when we sometimes call them ULPs, unfair labor practices. I said this before, union always tries to negotiate first before pulling the trigger on Labor Commission. And in fact, if there's one piece of I don't like to talk about Labor Commission strategy so openly, because obviously I don't know who's listening, but there's one thing that I think is pretty, universal for the union side, is that even if you've got an ironclad case, I think that the impression you make with Labor Commission is very important to how well received your claims are. And the purpose of Labor Commission is to protect your trade union rights, but I think that they see themselves as kind of guardians of labor peace, right? And so whatever we might think of that, having a government have that role in society, that is what I think they think of themselves as. And therefore, don't take kindly to unions that are just trying to use their process to, bother management, right? That's not something that we should ever do, right? And so, if you run right to Labor Commission, you're going to have less sympathy from the commission than if you made every reasonable effort, maybe you went beyond what would be considered every reasonable effort to try to resolve it, without involving the government. And so, yeah, I pointed out the Labor Commission process can take years. The Labor Commission often pressures both sides to settle and sees settlements as a point of pride. The most powerful way to discourage management from committing unfair labor practices is building a strong union with solidarity in numbers. And I would even say solidarity is more important than numbers. So, oftentimes me and my colleague Lewis will talk about how sometimes people think of solidarity as this like fuzzy concept, like it's almost a woo concept, like togetherness, or solidarity is showing up, solidarity is turning up to your union events, and it is so compelling to management, the people you're trying to convince not to commit unfair labor practices, and more than that, to agree to your demands, to see the solidarity of the membership and to generate respect for that solidarity, maybe a healthy fear and respect for that solidarity. And that is more effective than any legal process. So while personally, I rather enjoy Labor Commission, I enjoy the challenge of it, and it can be, you know, kind of exciting in a unique form of union activity. I also enjoy, there's a certain democracy to it. You don't have to hire a lawyer at Labor Commission. They tend, like, my Japanese isn't perfect, but they tend to be rather patient with it. There's a lot of nice things about that process, but it is not the goal, right? The goal is for us to be so strong that Labor Commission is something we never even consider, even when we do run into problems. I didn't mention this in my closing points, but there are other forms of conflict resolution outside of resolutions related to unfair labor practices available at Labor Commission. One is called Masen, which I guess mediation would be a good way to translate that. Tozen has had some experience with Asen recently. And this could be on anything, any demands you don't agree on. Doesn't need to necessarily involve unfair labor practices. The other one's chote, and I've never done one, but that's like a binding arbitration. Mediation and binding arbitration require both sides to agree to participate. While an unfair labor practices petition, management must legally respond to it and participate in the process if we ask for mediation or binding arbitration. If management doesn't agree to enter the process, or if in the middle of the process management chooses to withdraw from the process, that's their right. So these are available and they can be useful, but the most that we end up taking advantage of the services of Labor Commission is with unfair labor practices. So, you know, I hope that you found this interesting and informative. If your local is experiencing unfair labor practices or think you are, make sure you're talking to your case officer and talking to each other about it. And always remember to be very patient, because resolving any of these either at the table or in Labor Commission does take time. Oren, did you have anything you wanted to ask before we got to the questions from our audience? Sorry, before you do that, for those of you who came in at 1:30, because we put 1:30 on the T action list, I apologize. That was a mistake. And I will encourage those of you who ended up coming late for that reason, please go back to the beginning to watch, you know, whatever you missed. And, you know, we'll try to be more careful about that in the future.
So, yeah, I was just thinking, could you give us like maybe a little background, like how many tolerance cases have you done, or Labor Commission cases?
JCFL 1, 2, 3, and I think 4. Hart, Pearson. He did another one. So let's see. I'm undercounting, but at least 10 in Tokyo Labor Commission, maybe more than that. Yeah, no, but I would say like 12. Yeah. And you know, it's very rare that you lose every count. By the time you get to a Labor Commission verdict, you've gone through the entire process, right? If usually you win some and you lose some. So I know in all of my cases, I've won at least. We've won as a union at least one of the charges. So yeah, and we've done a couple precedent-setting cases. You know, the Gakugate case was so significant that, you know, ever since then, we're usually, with one exception, we're usually able to resolve language of collective bargaining. And yeah, I mean, so I've had more experience with Labor Commission than I was expecting when I first got involved in Tozen, I'll say that much. So anything else?
Yeah, how does so we kind of touched on like Central Labor Commission and how there's some similarities with labor commission in. So,
Say that again?
oh, actually, no, we didn't. So what's the process with the Central Labor Commission compared to Labor Commission?
I mean, you file a petition, and then you have to file, the first petition you file is just a couple of sentences, and then later on you have to explain how the reasoning of the Tokyo Labor Commission, in our case, because we almost always use Tokyo Labor Commission, how that reasoning was flawed, or if there's new evidence that came up that it would, change the verdict. I would say it proceeds very similarly. There tends to be more time between hearings, like Tokyo Labor Commission's every month and a half. Central Labor Commission, you're looking at like, it's usually every 2.5 months, but there's fewer hearings because there's less work to do. A lot of the investigation had been done at the first stage. And testimony is a little more streamlined, like you can't do it. You can't, but it's unlikely that they will allow you to, like, when you apply for testimony, you identify your witnesses, that you want, and you ask them to let you do testimony. They don't have, the commission doesn't have to agree. They tend to put pressure on you to make that more brief. And then it takes 6 months from the end to get to a verdict. So I would say that it's a slightly more abbreviated version of the Tokyo Labor Commission process. And the only thing that will make it longer is they will try again really, really hard to settle. And so you might have a few more settlement hearings. And with the fact that there's usually a lot of time between hearings, that can make things drag out. So I've had, once you get to Central Labor Commission, it can drag out another year, maybe more.
Okay.
Are there any questions in the chat? It doesn't look like it.
No.
Yeah.
Well, there is one person in the chat. Occasionally, Lewis. Do you have any questions? Anything you want to correct your own one? Or...
Jerome has a lot more experience than I do in the Labor Commission, and I would say one thing that often, like, I personally have an issue with is that, management cannot refuse collective bargaining, right? And we sometimes can win a case of refusal to negotiate or negotiate in bad faith. However, even if we win, the best we can get in most cases is an apology. Now, there is a system in the Labor Commission of fines that if management egregiously ignores all the rulings and just basically breaks the law, there is a system of, I think there's a fine of like 100,000 yen a day that they don't follow the verdict, but that's a very, very difficult mechanism to use. And so one thing I'm a little frustrated about the system is that you can get away with bad faith negotiations with nothing but an apology. And so we do a lot of work to prove that they refuse negotiations or that they negotiate in bad faith. And then all they get is a slap on the wrist, maybe a little bit of embarrassment. So that's something that I think we should think about. And on the other hand, if they fire someone because of union activity or because of striking, and we win that case, that's completely different because then the member gets all the back pay, they get the wages for all the time that they were out of work because of the union busting firing. So there's a strange discrepancy between those two unfair labor practices. That's all I have to say.
Yeah.
Thank you.
Like, first of all, it's considering how much experience Lewis has with, Lewis is, I think, probably one of two of the most experienced union organizers, foreign union organizers in Japan. And yet, I came into the movement fair amount later than he did here in Japan. So it's always weird to hear him say I have more experience with anything than he does. But I think there are some contradictions in the system. The length of time it takes, as I pointed out, does seem to weirdly serve a certain function of helping the process of evidence discovery. And also it gives the commission kind of a chance to get to know both sides really well. If things were quick, everyone would sort of put on their best face, and you can't do that forever. Eventually, like, management's doing a lot of terrible things and the union is, being diligent and earnest, that pattern is going to become apparent to the commission, right? So I think that that's the length the benefit of the length is in that, but, you know, of course, we often have that feeling that justice delayed is the same as justice denied. I tend to think that any hope for getting justice always requires time, you know, I mean, and so, you know, patience is the key. So, yeah. It doesn't look like there are any other questions, so I think maybe we can wrap it up there.
Yeah.
Okay. Well, thank you very much for those of you who joined us, and yeah, I will see you at your next local meeting, or if you are no longer, sorry, if you're not a member of Tozen but would like more information, please email us. It's info@tozenunion.org. I assume that'll be somewhere in the comments. And everyone have a very pleasant rest of your weekend. If you're going to be outside, drink plenty of water, keep yourselves hydrated because it's hot out there. Have a nice day.
And if you have any requests for us for any future streams or Tozen Daigaku, please feel free to email us at the same email.
Tozen da.
Great. Thank you and goodbye.